Hello and welcome to the Privacy Corner. I'm Robert Bateman, privacy and data protection writer, commentator, advisor here on behalf of Privado AI, a great company doing privacy code scanning, bridging the gap between privacy and engineering. And it's just me this week, but I've got some very interesting items to discuss. So here on Privacy Corner, which takes place every other week, we talk about the latest developments in data protection and privacy, try to get a bit deeper than the mainstream media coverage and look at the broader implications of the developments that have taken place in the week prior. Sometimes I have guests. This week I'm flying solo, but please do ask any questions you might have in the comments, and I will do my best to address them all. So this week I will talk about Tuesday's decision from the Court of Justice of the European Union, a competition decision that has major implications for data protection. Very important case. The class action in California against OpenAI and Microsoft, about which I have views, and also the latest decisions on Google Analytics, which have come this time from the Swedish regulator. Let's see what's interesting about this latest round of cases concerning Google Analytics. I'll talk through a couple of other things as well that have piqued my interest and recommend a few articles about data protection and privacy published this week. So off to the first item then. This CJEU case decided on Tuesday that there is a lot of buzz about. I think it came out of the blue for some people. This case came from the German competition authority. And I covered this when I was doing a bit of kind of journalism on privacy back in, would have been 2020 or 2019. So it's a long running case about Meta, specifically Facebook, and it's from a competition authority. So why should we care about this? Well, as I'm sure you know, competition and data protection are closely linked. When a company grows and acquires new businesses, it has new opportunities to gather more data, and importantly, to combine data about its users from different platforms that it owns. So this can help embed the company's market dominance. It's a kind of exponential effect. You have more platforms, you gather more data, sometimes about the same people, and you can combine that data to learn more about each of your users. So the EU's, or the German competition authority was concerned about this, and the CJEU's decision comes from an appeal by Meta against the competition authority's decisions. Now, there are some very striking conclusions in this case. I'm being relatively careful about how firm my assertions about this case are, because it's going to be one we're talking about for a long time. Lots of very smart people have had some very interesting stuff to say about it, though, and it's definitely a big deal. Here are some of what I think are the kind of headline findings in this case. It's called Case C252/21. Always catchy titles with these CJEU cases. So first off, the CJEU is very clear that competition authorities can deal with data protection issues. They can even find violations of the GDPR if they closely cooperate with data protection authorities, and if they do not override pre-existing or relitigate established GDPR decisions. Now, the court was not terribly specific about how competition authorities should be dealing with GDPR interpretation, because it's not really their patch. I think we can appreciate that. But at the same time, data protection authorities sometimes have to look at contracts to see whether a company can rely on Article 6(1)(b), the legal basis of contract. So there is a bit of a blurred boundary between these two disciplines, and the CJEU acknowledges that in this case. Now, some commentary has suggested that this might be another blow for the one-stop shop mechanism under the GDPR, whereby complaints that apply across different EU countries have to go through a controller's lead regulator, which is why we have so many cases coming from Ireland, because a complainant submits a complaint in Austria. You might know why I picked that particular member state. Austria has to refer that case to Ireland. And with the competition cases, the cooperation between competition authorities works differently. So we might see complainants identifying competition concerns that are secretly data protection issues, and perhaps getting their complaints in through the back door of non-Irish regulators. Could happen. Now, the other thing that the CJEU had to say on competition authorities or antitrust concerns in general is about the legal basis of consent. Consent under the GDPR is strictly defined and has to be freely given by the data subject. Now, in some contexts, for example, employment, consent is not appropriate because your boss a boss and their employee have a power relationship, and consent might be coerced, even if not explicitly. The employee might not want to consent but feel that they have to. Therefore, we don't encourage consent as a legal basis in most employment contexts. But what about a big company that dominates a market? Could that be a power imbalance in respect of the legal basis of consent? The CJEU says maybe that could be a consideration for a competition or even possibly a data protection authority. So we might see a company like Meta, which has a very large presence in the social media market, struggling to rely on consent in certain circumstances. Now, the CJEU didn't say that Meta can't rely on consent for personalized advertising, of course, but it does suggest that the fallback for Meta might not be as simple as it seemed. So there's some other stuff on other legal bases too in this decision. Contract. So Meta, as you'll know, formerly and currently in the UK, relied on contracts for providing certain types of targeted ads to its users. So if you sign up for Facebook, you agree to the terms of service, and previously you also agreed to receive or have your data processed for targeted ads. Now, the Irish Data Protection Commission very reluctantly told Meta that they can't do this anymore. So Meta switched to legitimate interests in the EU. And the court agrees with the European Data Protection Board's views about contract. Processing has to be necessary for performing a specific contractual obligation or entering into a contract. So if the processing does not take place, the controller can't perform its contractual obligations. Now that's, according to the CJEU and the European Data Protection Board, not the case when it comes to Meta's ad targeting. This is not necessary for Meta in respect of providing its sort of core services. Meta argues, probably reasonably that it is necessary to support Meta's business operations in general, that, according to the CGAU now, as well as the European Data Protection Board, is not a valid reason to rely on contract. There needs to be a link between the performance of an obligation and the processing of personal data, a direct link. So, consent questionable, contract is out, legitimate interests, which Meta has now switched to for ad targeting, also coming into question in this CJU case. Now, the judgment is a bit fuzzy in this area around whether it was talking purely about third-party ads using data from other non-Meta properties or other controllers and platforms, or just first-party ads, or first-party ads as well. So either first or third-party ads, first-party being data collected purely on the Facebook platform. But it does seem to suggest that legitimate interest is out for personalized advertising. The assertion by the CJAU, also made by the European Data Protection Board on several occasions, is that Facebook users might not reasonably expect that their personal data would be used in this way. The court didn't go into a lot of reasoning for this assertion. I wonder about that. Noip has done some research that supports that assertion, but nonetheless, it looks like legitimate interest is no good for Meta either. So we've now got contract, no. Legitimate interests, no, basically. Consent, maybe not either. So this is a real problem for Meta. Finally, the other interesting thing in this case was about special category data under Article 9. So this is sensitive data about race, religion, ethnicity, sexuality, all those sorts of things. Now, the Meta was relying on one of the legal bases in Article 9 for processing special category data, which is that the user of their services had manifestly made the data public. This was not considered an appropriate use of that legal basis by the court. So manifestly making something public means that you expect it to be available to a potentially unlimited number of people. Using a website, clicking around, filling in a form even, is not manifestly making special category data public. Now, there are serious implications to this because the CJAU also says that special category data that can be inferred or derived from normal personal data is still special category data. So using Grindr might suggest something about your sexuality, for example. It doesn't have to be an explicit statement that you are gay or straight. You can infer someone's special category data. This is a bit of a big deal. Kerry Leaning goes into this in her newsletter this week about, well, how exactly are controllers going to justify, for example, giving someone directions to a gay bar on Google Maps? That is inferring special category data about them, perhaps. And do they have to get consent for it? Can they get consent for it? What are the bases available for that? So big implications here. This one will go on and on, I think. The CJU decision will now go back to Germany, so we'll see what happens when the court applies that. So this OpenAI and Microsoft lawsuit you might have heard about. So some plaintiffs in California are asking for $3 billion from these two companies, and they make a very large suite of privacy allegations. Now, the press, for some reason, has reported on this as though it were a privacy and intellectual property case. I don't see anything about copyright in there or intellectual property. It just seems to be privacy. And I've got lots to say about this, so it is interesting. The The complaint cites a lot of laws. So you've got California laws, you've got Illinois laws, New York laws, federal laws, you've got torts, so that's civil wrongs, and you've got privacy and consumer protection laws, lots and lots of stuff. They've thrown everything at this case, and they've also snuck in some laws under some of their particular causes of action. So let's look in a bit of detail, because the coverage on this has been a bit credulous, I think. It is significant, and it will be significant if they get a settlement. It's not, there are problems with the case, in my view. So we'll talk a bit about what they're claiming. I'm just really confining my analysis to the latter part of the case, which lists the actual laws that OpenAI and Microsoft are alleged to have broken. The first half, or the first 2/3, 100 or so pages, are all about the various privacy transgressions and quite emotive sort of language. Then they get to the meat of what they're actually claiming. So I'll select some of the laws that they cite. There are lots, as I've mentioned. There is the Electronic Communications and Privacy Act. That's called ECPA or ECPA. I don't know if people call it ECPA, but I will do so. This is a federal wiretapping law from 1986. And you see these wiretapping laws coming up quite a lot in privacy class action cases, because although it sounds quite archaic, wiretapping, you think of Watergate, and it's the language of picking up a rotary phone and dialing down a cable. They do have some analogous use in privacy and modern internet communications cases. It's all about intercepting communications, and they are kind of technologically neutral, so they do apply to some extent to online communications. So EGPA is quite an old law, but arguably still applicable. This is one of the more interesting arguments they make, and they accuse OpenAI and Microsoft of a number of different violations of this law. One way that the defendants allegedly violated ECPA is by using the ChatGPT API. So this API, third-party companies can install it on their websites, and it acts as a chatbot powered by OpenAI's generative pre-trained transformer, the GPT model. So what they're saying is, I, as a user, am trying to communicate with a third-party website. ChatGPT's API is popping up and intercepting our communications. Now, the case, as I say, uses quite strong language. These US cases often do. So Microsoft here is accused of engaging in a calculated scheme to intercept the plaintiff's communications via this ChatGPT API without any iota of valid consent. Now, I don't know a lot about how this law has been interpreted by the courts. It's one of the stronger, or the least problematic areas of the case. We then got the Computer Fraud and Abuse Act, another old law, 1986 again. I'm not sure if that's a coincidence. And this is a kind of old school cybersecurity malicious acts sort of law that prohibits a person from accessing someone else's computer without permission. And the plaintiffs allege that Microsoft and OpenAI did this by using cookies and other technology, and also some plugins. Now, there's some sort of exception in this law for violations that result in damages of less than $5,000. So the plaintiffs say, well, as a class, we've lost a lot more than $5,000 because of the diminution in value of our private information. A couple of issues with that, I think. The court, well, there is some private information arguably here. Most of it is not private information. It's publicly available information, which is kind of it's almost fair to say it's fair game under US privacy law in most cases. Also, the value of personal data, it's really tricky to measure, and the US courts, there aren't many precedents for assigning specific monetary value to personal data or private information. Then we've got some California laws, the Invasion of Privacy Act, CIPA, the CIPA, as I am pronouncing it. So this is a 1960s wiretapping law, and it's slightly stronger than ECPA because it's a two-party consent law. So under this one, both parties to a communication need to consent to the interception of that communication. Under ECPA, only one party has to consent. So you can see why CIPA is slightly stronger, and they don't necessarily have to worry about having the OpenAI, the Chat GPT API as the sort of man in the middle. Also, there's statutory damages under CIPA, so it's $5,000 per violation. So that makes it a bit stronger than ECPA for the California class in this case. It comes up a lot in third-party cookies and tracking cases. I must say, even if you don't lose a case like this, nobody wants a class action, a high-profile class action lawsuit against them for cookies or anything else. So you'll see the press coverage of this does not put OpenAI and Microsoft in a good light, regardless of the strength of the plaintiff's case. Then we've got the California Unfair Competition Law. So this is a consumer protection law, and they use this to kind of shoehorn in a bunch of other laws under which they lack standing. Standing meaning there's kind of right to bring a case under a given law. So because the unfair competition law requires companies to act lawfully, they say that the defendants have broken a bunch of other laws that don't give rise to rights in court, like CalOPA, the old California Online Privacy Protection Act, which requires a company to basically write a simple privacy policy. They say OpenAI have failed to comply with that law. It's pretty easy to comply with, but you know, they might have missed one or two items off the list or something. They've also put the California Online Privacy Protection California Consumer Privacy Act, the CCPA, which does have a private right of action, but only for data breaches, which they do not allege has occurred here. So they're kind of using it to shove in these other laws that don't have rights of action in court. Also, COPPA, the Children's Online Privacy Protection Act, that they allege has been broken. Not sure that applies to these companies in this context, but there we are. So you can see how they're using this unfair competition law to get other laws in through the back door. Apparently, I'm told by a lawyer on Twitter, the courts don't like this. They don't like the unfair competition law being used in this way as a vehicle to allege other violations. So look, I mean, I would just mention a couple of other arguments made by the plaintiffs. The Illinois Biometric Privacy Act, Illinois Biometric Information Privacy Act, BIPA, comes up. This is not appropriate here, I don't think. I might be missing something. They say that by using the plaintiff's facial images for training the GPT model, their biometric information has been collected without consent. A photo of someone's face per se is not biometric information. So unless OpenAI is assigning biometric, mathematical identifiers to this person's face, then I don't think they've violated BIPA. But there are a lot of class actions under that case, so I kind of wasn't surprised to see it there. And then we have negligence, invasion of privacy under the Constitution of California, various other tort and constitutional allegations. They might get a settlement out of this. OpenAI and Microsoft, it will be unwelcome for them either way. I'll be very surprised if the plaintiffs win, but it could get pretty messy either way, and never rule out a settlement. They might just settle to avoid having to read this 150-page long court docket. Who knows? So last thing to mention is the last main item, Google Analytics. We've had 4 companies in Sweden sanctioned for using Google Analytics. 2 of them are fined. We don't normally see fines with these GA investigations. One of them fined for about €1 million. So that's, that's not small change for most companies. And this is all about the data transfers. They didn't look at the other compliance requirements under e-privacy and GDPR. So the companies had been using standard contractual clauses, as everyone does with Google Analytics, and did not have supplementary measures in place. A few unanswered questions, I guess, from these cases. It was using an older iteration of Google Analytics. Most data protection authorities seem to extend their skepticism about the compatibility of Google Analytics and Chapter 5 of the GDPR all the way up until the latest versions of Google Analytics. But I don't think we've actually had a decision on the latest version of the product. So you have to treat these decisions carefully, I suppose. Sweden, like every other DPA, has not banned Google Analytics, but it has told 4 companies to stop using them, and those decisions are relevant to most other users of the product. So more Google Analytics action. Of course, that could be solved, in a few weeks, because the US has done its side of the deal with the EU-US data privacy framework. So there could be a new adequacy decision soon. And, that might temporarily solve all this US data transfer stuff. So just a couple of minutes left to recommend some reading. The Washington Attorney General has come out with some Q&As on the My Health, My Data Act. So that's quite handy. If you have a look at the Washington Attorney General's website, these are all in the newsletter, by the way, which Privado published yesterday. CPRA regulations have been delayed until March 2024 because the regulator was a bit lax in how it passed those regulations in a prompt manner. There's a good article from a law firm, Fisher Phillips, talking about the implications there. Just the regulations here. The law is still in effect. And there's more stuff on the UK's online safety bill. I'll take this opportunity to do my small part and insist that you read all about the dangerous, privacy invasive clauses that have been added to the online safety bill. It's not good. So do read the letter from 68 researchers urging the government to reconsider this particular law. So that's all we got time for this week. If you're still watching, thanks so much for sticking with me. And a quick plug for Privado AI, who provide this space for me to talk about privacy every fortnight. It's a developer-friendly privacy platform that focuses on privacy engineering and really wants to help engineering and privacy teams work together with code scanning, understanding how your app works, what data it collects, what data it shares, mapping and recognizing the different types of personal data, the APIs, SDKs that can really get companies into trouble. So check out Privado AI, great product, lovely company, and thanks so much for joining me. Hope to see you in a couple of weeks.